Good morning. Thank you for joining us. Today is our third monthly office hours. This is a series of webinars that Thomas Dot and CoveyLaw are producing collectively, cooperatively, to keep our communities informed about upcoming changes and progress, regress, all the different things that are going on in immigration community in the U.S., in the immigration field. Today, I'm happy to be joined by two of my colleagues, Amanda Gupta, who's a partner at Covey Law, and J.R. Strauss, who's an associate at Covey Law. And the topic is to talk about EB-1 visas, which are often referred to as green cards, and what's happening, what we're seeing in that field, and how that's being impacted by current changes in U.S. immigration policy. Again, my name is Matthew Covey. I am a middle-aged white male with a beard and a blue turtleneck sweater on. Um, Really glad that you all joined us today, and I will be monitoring the Q&A, the chat. So if you have questions, please feel free to put those into the Q&A. I'll be going through those, and once Amanda and JR have given their presentation, I'll be uh, filing through those questions that have been submitted over the course of the session, and we'll be asking them. And that's pretty much the intro. I think we can, if unless we feel like we should be waiting for more people to come in, I think that we should probably get started. We've got 50 people. That's probably pretty good. Let's get going. I'm going to start with some questions. First question. Let's start with the basics. We're talking today about the EB-1 visa. What is that? And what's the difference between the EB-1 and what a lot of artists use in the US and a lot of arts workers use, which is the O1? Do either of you want to jump in and talk about what is the EB-1 and when is it appropriate to use that?
Sure. I will do that. Hi, everyone. I'm Amanda. I am a white, middle-aged female with long, light brown hair and glasses on. All right, so let's jump right in. So the EB1 is a green card classification. So it's for lawful permanent residents, right? As opposed to the O1, which is a temporary work visa. So, it is similar, but also different to the O1. So I'm assuming that many of you understand what the O1 is. It is a work visa. It is based on, quote, extraordinary ability. And despite the fact that the EB1 green card application has that same description, it's the green card for those with extraordinary ability. It does have a good number of differences. So I think one of the more common um, myths that we get that a lot of potential clients believe is that there's a direct kind of path from having the O1 to being able to go for the green card, the EB1 of extraordinary ability. Um, and that's not, unfortunately, that is a myth, as I said. It's not that simple. You basically have to qualify for the EB1, and there are plenty of people out there who qualify for an O1 who do not qualify for the EB1. So we'll JR and I will get into that a little bit more. But let me kind of just go through very quickly the big differences here. Um, Again, O1 is a temporary work visa. The EB1 is a classification that is for permanent residents. So the only reason why one would be going for this EB1 is if you intend, and maybe you already do, but if you intend to live in the US, primarily work in the US, of course, understanding that, lots of artists and creatives travel a lot and maybe they work for entities outside of the US, and that is all okay. One of the bigger ones is pay taxes in the US. And when in fact you have any sort of a green card in the US, you're going to be expected to pay taxes on worldwide income. So that's a big one. That's a huge difference here. Um, the let's see. And the last difference I'll give you really quickly is that the application process itself is also very different. So again, we can get into this a little bit more detail, maybe, in a little bit, but The O1, as a lot of you probably know, you apply for the O1. If it is approved, you just head to the embassy to get that visa issued into your passport. Yes, you are interviewing at the embassy unless you are Canadian. You're interviewing at the embassy to get that visa put into your passport, but technically it's still kind of sort of like a one-step process. With the green card, with the EB1, you're applying for the actual eligibility first. And that is, it feels a lot like the O1, except it's more intense because the standard is higher. And only if you are approved are you then granted the ability to actually apply for the green card itself, which is a completely separate second process. And so what we're focusing on mostly today is this first step. The actual process of what does the eligibility look like? Are you eligible? If you don't think you are, how could you get there? But it is a much longer, more laborious process that actually occurs in two steps.
Well, that kind of makes sense. If you're fixing to stay in the US permanently, that's not too surprising that it's a longer and more complex process. Um, I guess the question that we often get is, especially for artists who have, or anybody, but I'm thinking of artists, of course, who have been in the US on a number of O1 visas. How do you know when you're at that point where rather than just renewing your O1 every 3 years or however whatever kind of cycle you're on, when is the time that it makes sense to make that big leap and go in for the EB1? Is there anything that people can be doing while they're on O1s or in other kinds of statuses, but anything that they can be doing to prepare so that when that time comes to seek permanent residence, that they have a better chance of getting it?
I can take this one.
Awesome. Thank you, JR.
My name is JR, and I am a middle-aged white man with a beard and a level of gray in my hair that I would put at German expressionist film. Uh, so this is a question, well, pardon me, that everybody asks. They want to know, when am I ready? Because the EB process is very time consuming and it's expensive for a lot of different reasons, both for legal fees and lawyer fees. And it's like emotionally kind of draining. It's everything about the EB1. And the EB1 is broken up. There's EB1 A, B, and C. It's not just one monolith. There's different subcategories, sort of like the O1. There's the O1A, O1B, O1 TV film. Everything is pushed to the maximum. So it's a daunting process. So I think in terms of, am I ready for it? There isn't a one size fits all answer. And a lot of times we hear from people like, well, I have friends who do the exact same thing that I do. They have the exact same job title and they just got a green card. And sometimes I have to tell people, your friends are our enemies because anecdotal experience, it doesn't really get into the nuts and bolts of the EB1. Uh, I had a boss when I started out, this is like 10 years ago, and when clients would come in and ask about EB1, they would say, am I ready? I've had three O1s already. I'm making a lot of money. I'm on these great projects. And he would say, well, it's a level of magnitude harder in that EB1 is, kind of the top of the hill. And literally in the regulations, these crazy regulations that were written 30 years ago almost, it says you need to be at the top of the field, which seems like weird language to be in a law, but that's kind of what the regulations are saying. So you have to be not just good, but really towards the highest echelons of the field. And some people try to say, well, that's like the top 5% of people or the top 10%. I think that's a little bit reductive. But this boss that I would have would say, well, the O1, you're in the magazine, and EB1, you're on the cover of the magazine. That's very general, and obviously that's not at all what you need. You don't need to be on the cover of Vogue to get an EB1, but to give you an idea of what we're looking for, it's that you have to really have shown that you stand out in the field. And even if you are really good, the heartbreak of the EB1 is that the way that the evidence that we submit works, some people have it, Maybe your friend who got the EB1, who isn't as talented as you, just happened to have the right kind of evidence to satisfy the categories. There's 10 categories under the EB1. You need to hit three of those, a minimum of three. Uh, Sometimes that you just don't have the paperwork and you can be really great. The other thing that you have to keep in mind with the EB1 is you are being reviewed by somebody in a distant part of the country who may or may not have any idea about what you do. Maybe you are a really talented painter. Maybe you're an incredible musician, but it's an instrument that people aren't really familiar with. Maybe you've done things that are impressive within your community, but something that a reviewer for USCIS, that's immigration, they don't really understand it. They don't get it. So sometimes we're seeing adjudications where the reviewer is just bad and it has nothing to do with your career. It has nothing to do. And the O1 is very similar. You can be very talented and you could just happen to pull a bad reviewer. So I would say, what can I be doing? Or to the question, what can I be doing to get ready for this? Uh, this is something that isn't weeks to prepare for. This is something that takes months. There are, the evidence that you have to collect in some cases will be a little bit different from the O1 because the EB1 exists, the EB1A specifically exists to have everyone that has an extraordinary ability apply for a green card. So that includes people who had O1s in business or athletics or medicine or research. That's the O1A standard. And the O1A evidentiary rules and the required criteria are different than the O1B. Not totally different, but enough that you might not have some of the evidence that gets transposed into the EB1. So, for instance, in the O1A, they're looking for evidence of original contributions to the field that have basically changed the field, or memberships that require elite achievement, or that you served as a judge on the work of others in your field. That's not something you may have prepared for an O1. So it's something that you would need to revisit. I think this is a little bit self-serving, but it's true. You should talk to a lawyer or somebody that has experience working with the EB1 because now more than ever, getting approved for an EB1 is as hard as it can be, really, and for a number of reasons. Those adjudication processes we just talked about. The fact is that everybody's getting better. You're competing against everyone in your field, and your lawyer's job is going to be determining what you have, what you need, and in some cases, how can we change your title or work with your title to make it easier for you to get approved?
Thank you, JR. That's really clear and very helpful. I want to just mention one thing here, and that's that there are a number of different ways to get a green card. Um, so, if you're a film producer and you've got a friend who's a film producer and they say, "Well, I've got a green card," it may not be because they got an EB1. It may be because they married an American. So just because somebody's got a green card doesn't mean they went through this process. Um, that's probably obvious to most of the people on this call, but I just want to make sure that point of confusion is we're heading that one off. JR, you mentioned something about how right now it's harder than ever. I guess I'd like to both now and kind of as we continue to talk about this stuff, it'd be really great if you could both reflect as we go along on how are things, what are we seeing in the field that's changing? I know that in a lot of ways, there's enormous changes that are happening in U.S. immigration policy and enforcement, but there's also some backwaters where things are not changing at all. And I think it'd be really useful for the people who are listening today to kind of have a an ongoing update as you go along with it. This is new. This is the way it's always been, just to help people understand how much things are changing, how much harder it is getting, and how much it isn't. So, but I think that's a good place to start. Is it harder to get an EB1 now than it was, say, during the Biden administration?
It's
Yeah, why
always
don't we
been hard.
split?
Oh, yeah,
Can we split this one up?
yeah.
No, yeah, exactly. It's always been hard. And I think JR and I would both say, yes, it is harder now. It is a little harder now, but let's break it down. So how about JR actually has more experience in the immediate right now with EB1. So I'm going to let him speak to his experience. But I do want to say I want to explain to everyone really quickly so that when JR explains, this will be easier to understand when he gives some of his current experiences. It'll be easier to understand. So when JR mentioned narrowing of the field, or when JR mentioned the field, right? We have to prove that you are one of the few who has reached the top of your field. What does that even mean, right? And to JR's point, does it mean that you're at the 5%, the 10%? There's not a lot of guidance, and that can be good or that could be bad. And it depends on the officer who's looking at your case. But what's important to know is that the way that we build these applications is we're trying to satisfy as many of the eligibility criteria as we can, right? Just like we do with the O. But then when USCIS looks at the case, they're going to look at how many of the eligibility criterion do I believe as the officer are satisfied. Okay, fine. You have to have at least 3. So if the officer believes, yes, there are at least 3 eligibility criteria here that are fulfilled successfully, now I'm going to do a completely second analysis. And that second analysis is, do I believe that this and everything else in this petition generally, am I convinced that it means this person is at the top of their field? So when you're thinking through, and this is what lawyers who do these cases all the time have to do, is say we kind of look at it in 2 steps here. It's like, how many of the eligibility criterion can we satisfy in a strong way? But ultimately, how are we going to make that argument that it means that they're at the top of their field? And so one of the things that we do with every single EB1 we work on is try to narrow that field. One, how do we narrow the field, right? So for example, if you are an actor, if you are let's say you're an actor, you've done stage and screen, but lately you've been much more prominent on screen. We're going to look at we're going to try to still, regardless of the fact that you are an actor in general, stage and screen, we are going to narrow it as much as we can. Is there a specific genre that you act in? Do you do all the crazy characters in the Star Wars film? Have you been, the monsters and vampire movies before? Like, are you, could we say that is your very specific niche? Could we say that you do period pieces? How can we narrow that field? So anyway, I'm going to hand it over to JR, but I just wanted to explain kind of that 2-step analysis that they do, because that's going to help you to better understand JR's current state of things.
Yeah, thanks, Amanda. That you couldn't have set that up better, because that second step analysis is a big trend that we're seeing right now. And by we, I mean not just CoveyLaw, but attorneys across the country, and indeed attorneys that practice outside of the US that are doing immigration law. So what we're seeing a lot of right now is USCIS going through somebody's petition, and they say, okay, I see that you have evidence that you were a member of an organization that required elite achievement, high level achievement, and you gave us a letter from the organization, you gave us their bylaws, you let us know everybody who judged your application. Yes, we're going to say that you satisfy. Looks like you have done 25 exhibitions. That's going to satisfy what we call the showcase criteria. They say yes with that. And then maybe they find 2 or 3 other categories that we have evidence for, and they say yes, yes, yes. And then they get to this second stage of the analysis, which is called, in some cases, the Kazarian analysis, which is based on a benchmark case in immigration law about this specific immigrant visa. And during this second step, we are seeing, I don't know what the percentage is, but certainly the prevailing trend that's being reported is USCIS is saying, yeah, you have 8 categories in some cases that you have satisfied, but we don't think you are at the top of the field and that you have the sustained acclaim that is part of that Kazarian analysis. Because it's not just that you've risen to the top of the field, but the second step also requires the evidence to prove that you have a sustained level of talent and success from, now that you are at the top of the field to an undetermined amount of time before, an indeterminate amount of time. So let's say for the last 3 or 4 years, you've been getting press, getting awards. And what is really frustrating about this process is that USCIS can say, nope. and they don't have to give a lot of explanation as to why. Uh, my recent experience that Amanda can speak to is that USCIS sometimes doesn't give any response right now. We're seeing a lot of really sloppy RFEs, and an RFE stands for Request for Evidence. The RFE is one of the dirtiest three letters that we have in immigration. When you hear that, is a precursor to USCIS saying, we're thinking about denying this because you didn't give us enough or the right kind of evidence. And it's always been a fight. And it's unfortunate because it shouldn't be an adversarial proceeding. It should be us asking for a benefit, which is this green card, and they say, yeah, we think you have the evidence, or we could use a bit more. It has changed significantly where it does feel like there is an aggressive posture from USCIS right now. And some of that is coming from the current administration. There's a feeling in the air where they are more aggressively vetting petitions. But this isn't something that happened overnight. I started practicing, during Obama, and we were seeing, as many of you I'm sure know, um, deportations and detainments increasing under Obama. We were seeing crazy RFEs happening under Obama. We were seeing crazy RFEs happening under Biden. So it's not too strange. And the thing is, and this is not a conversation for this talk, but it's just knowing that this system is not a great system. This system is jury rigged. It is held together with string and bubble gum. It's decades of not really paying attention to what modern immigration requires and putting band-aids on it over the course of years. So we're at a point now where we're at the mercy of adjudicators that even if they have no political animus at all, there's not a lot of oversight. And in some cases, they are contractors. And to give you an idea of how sort of perilous this adjudicatory system is right now, they don't tell you the names of the people who review your petitions or they submit the RFEs because years ago people were finding them and getting very mad at them. So if you ever get an RFE, you get a nice letter, nice is relative, I guess, from the service center, and they'll say, this is everything that was wrong with your petition as confirmed by reviewer XM dash 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 dash. There'll always be letters and numbers. So that gives you an idea that they are trying to anonymize the people who are looking at the petitions. But again, to go back to the more immediate thing, it's the step two that is getting a lot of attention right now. But in general, just lazier RFEs is the common trend where we'll put evidence in and they'll say, no, you didn't satisfy. And they are supposed to tell us why it didn't satisfy so we can respond to an RFE. And to give you an idea, when you get an RFE, you have a couple of options. You can respond to it and hopefully get approved or maybe denied. You can not respond to it at all, and by the date specific set out in the RFE, you will be denied. Or you can withdraw the petition if the RFE is so aggressive, you think there's no way I can overcome this. And sometimes that's a decision. There's a strategy involved with that where you withdraw and refile, sometimes having to pay all those fees. But uh, I think in terms of what we're seeing right now, it's just adjudications are not as clean. Even if they were bad in the past, they were supported by some kind of like internal, admittedly strained logic. Now I just got an RFE. I think Amanda, you're kind of alluding to this. We got an RFE for somebody. There is, in addition to the 10 categories for the EB1, you can satisfy the EB1 by having proof of a one-time award of major significance. And it's usually the examples that are given by USCIS will be an Oscar, a Nobel Prize, the biggest award in the field. And we had submitted a major award, and CIS looked at it and ignored it and said, this just doesn't work. And there was no explanation for why or how it didn't work. And that means the client, through no fault of their own, has to give us a ton more evidence and weeks of work so we can satisfy other categories. And that's just because the trend right now is unfortunately not great responses to the evidence that we submit. So the thing to think about is when you're working with a lawyer, and all the more reason to work with a lawyer, is we are always going to be pushing you to get the best evidence possible. And sometimes hopefully this is the hardest thing you have to do in your immigration journey. And it's going to be hard, but I think now it's absolutely required to make sure that you're getting the most bang for your buck. This is expensive, it's time consuming, and sometimes it has to be in order to overcome what is a not great adjudicatory posture right now.
That's really helpful. Um, there's a question that just came in on the Q&A chat, which I think is material to this. Um, the topic you're raising, JR, about like what kind of assistance people need. The question is this: say you have all the evidence and qualify for three plus categories, and you put together your evidence yourself. Will a lawyer look over the petition you put together? Um, there's probably a lawyer who'd do that, right?
That's a good question because you're trying to save money.
Yeah, makes
And
sense. This is crazy expensive.
yeah,
So,
what's interesting, and this is the same thing with like my friend. My friend got an O1 or got an EB1 and they did all the work by
right.
themselves. Why can't I do that? Maybe your friend was, the one in 30 people that pulled a reviewer that was happy with that work product.
Mhm.
Or you're in a field or your friend was in a field that's so rare and special that the quality of the evidence maybe isn't as important. But generally, lawyers want to do things the way that they know how to do it. It's like any other profession. It'd be, an attorney, a plumber, a welder, a mechanic. I think I'm giving ourselves a little bit too much credit by comparing us to plumbers, but in that we know how to do things a specific way. And like at our firm, we have developed strategies and we understand the regulations and how the evidence works, hopefully in harmony with the regulations in order to satisfy what the adjudicators are looking for. Uh, I think when clients come to us and they say, "Oh, I've done everything already," that makes me personally nervous because even when you have the best intentions, or even when you're hoping to save some money, which now more than ever I completely understand, it's that the evidence really needs to be specifically tailored to hit elements of the regulations that you might not even be aware of. The plain language of the regs is just the start of the story. There are adjudicatory trends. There are memos that go out from USCIS saying, this is kind of how we're interpreting things right now. There is the USCIS policy manual that if you feel the need to, get a little sleepy later, jump in there and take a look at the policy manual. And it goes into the minutia of how they're reviewing certain categories. And to read the policy manual, to read the regulations, it is very, very complicated. And even though USCIS has a standardized template that they use when they are reviewing petitions, some reviewers just don't get it, or they interpret what is already a series of regulations that are a little too open to interpretation. Matthew and Amanda, I think you probably agree with that. I think you just get a reviewer that sees it differently. So our job is trying to take this evidence that you have and make sure that it goes through the filter that they understand, and that they are looking at a document that they can say, all right, this evidence checks all the boxes for me. I'm going to say yes to it. More often than not, clients will give us letters in particular, and letters for an EB1 have a very different purpose than in an O1, and how they are reviewed by CIS is very, very different. Uh, so that's an example of places where, yeah, you need to have a lawyer look at stuff because one wrong sentence, one wrong term, I knew so and so when they were doing freelance work in 2015, and maybe you didn't have a visa at that point in time. Like little things like that, where you're putting things into the record that you don't want in the record, or trying to explain experience that doesn't check off the elements of a regulation, because like all law, regulations are based on elements. And sometimes you don't, as a person that doesn't come in contact with this a lot, you might not be able to see each of those elements that need to be satisfied. But also the bigger picture is this is our job, and we have set up stuff to make our jobs as efficient as possible for us. And every lawyer has a different way of doing it. It's possible that you could have somebody that's maybe starting out, or maybe you have an incredible ability to generate documents that most clients don't have. maybe that lawyer is willing to work with you. But I would say in my experience over the last 10 years and now at four different firms, uh, it's going to be different at every place, but for the most part, we want to be really working with you to make sure that the evidence does what it can do and it's the best possible application of that documentation.
And so I'll just add to that, that also from our perspective, if we get that type of an inquiry, right? Someone saying, I think I have a good EB1 application here. Would you just be willing to just review it for me and just charge me a small fee just to kind of review it? For us, I mean, this is kind of the great thing about lawyers and the annoying thing about lawyers is that we're going to dig down. We're going to dig down really deep and we're going to go down a rabbit hole when we're reviewing what you've put together. Because one, we don't know if it's actually everything that you have, right? We don't know if there's parts of the eligibility criteria that you read a certain way, but we know for a fact that the government interprets it a different way. So there could have been other documentation you could have included that you have, but without us asking you for it, you might not have included. So all of that said, a lot of lawyers will be reluctant to do this because they're going to say, I'm not going to sign off on something. I'm not going to look at something, sign off on it, tell you that I think it's good to go. And then you file it and get a really terrible RFE. Like you might blame me for telling you it looked good and it was okay to file. And so that's one of the reasons why a lot of lawyers will shy away from doing that. And then lastly, let's say that you do it anyway, you file on your own, you get a really intense RFE. If you reach out to a law firm at that point and say, okay, I tried this on my own, I filed it, it got a really bad RFE, will you please, I need your help responding to it. That is, again, for us at least, because we're going to say the amount of work we're going to have to do to review everything you submitted, internalize it, analyze it, then talk to you about, okay, do you have X, Y, and Z? Do you have all these other things? And then we're going to have to respond to that request for evidence. It's going to cost a lot of money because generally at that point, lawyers are going to charge on an hourly basis to be able to do that. And it's going to take a good amount of time. So I think you could do it. If it works, wonderful. You got really lucky, but if you do it and it doesn't go well, it's going to be, I think, harder and more difficult.
So you're saying it'd probably be more expensive to undo an RFE than it would be to just do it from the beginning? JR saying yes. Amanda,
I say
possibly.
possibly,
Okay. I
possibly.
did. I would say with this though, like we do hear people doing it themselves, and I think what it comes down to, and is, I mean, agreeing with what both of you have said, if you've got a lot of time, you've got a lot of time to put it together. I mean, a lot of time, and you're a pretty linear thinker, and you can really work with what you find, what kind of resources you can find to help you. And you've also got a lot of time so that if you get an RFE, you can dig back into it and spend many, many more hours responding to that RFE. You might be successful. It might take many, many more months to do it yourself. If you're under a time frame, or if you're under a time frame which like this needs to be handled quickly, and if you don't have kind of infinite hours to spend to prepare it, then that's probably when it's a lot to expect that a layperson who doesn't do this all the time can be successful in a sort of a reasonable time frame with a reasonable amount of work.
Yeah,
Um,
I totally agree with that. And I think someone asked this goes directly to one of the questions that someone asked in the Q&A, just simply about timeline, right? So generally, and this will actually answer another question someone asked. Like I said, the whole thing is a two-step process. It's establishing your actual eligibility, which is what we're mainly talking about today. Then it is, if that gets approved, it's actually filing for the green card. It's going through the actual green card process itself, which that part can be done inside the US or it can be processed outside of the US. While you are going through the eligibility side of the EB1, so you are just simply trying to convince USCIS that you are eligible and they should approve you for the EB1 classification, that gives you no status. So the good news is it doesn't take away anything. It doesn't take away your ability to travel on an O. It's assuming you're on an O or on an H-1B. It doesn't take away your ability to travel, but it also does not grant you any status. So that said, we generally recommend that you have at least a year and a half, left on an underlying status, right? So again, I most likely that's probably an O. But it's important to understand you need to maintain that underlying status while you're going through this part of the process because it makes things way less stressful for you to have, so you don't have to worry about your current status and whether you can stay or you're stuck here, you have to go. That's really important.
There's a question here. Thank you, Amanda. There's a question here that's what is usually the price breakdown between this first step and the other one? And I think the question that the way I'd like you to answer this is, there are different prices that different firms charge. Some are very, very, very expensive. Some are really, really cheap. Some situations you get what you pay for. Some situations not. Some there are people who do really good work who aren't that expensive. What's the kind of range of cost of the two parts of the process? Or if it's usually packaged together, what should people be thinking about if they say, I think I want to get an EB1?
Uh, yeah. Okay. So, first of all, I would say holistically, if you're looking at working with, a lawyer to file for the eligibility and ultimately get the green card itself, I would say the range would be, I mean, this is going to be a huge range, right? Assuming that, again, there are people out there who do it for significantly less and people who charge crazy amounts of money for it. I would estimate between 10 to 25,000. I mean, and
Got
that, like I said, that includes the government filing fees. That includes potentially expediting if expediting just on the
it.
front end. That includes, and a range of attorneys' fees.
Great. Thank you. Um, Another interesting question here. What about rare professions that might work on topics related to democracy or might be sensitive to the current environment? Like, are we seeing EB1s adjudicated with any kind of sense of the sort of the politics of the moment? Like, if you are a journalist who has worked significantly for more left-leaning publications around the world and you're trying to get an EB1 in the US, will the politics of the work that you've done in the past be more like, might that impact your ability to get an EB1, or do we not really know?
This is an answer that when you go to law school, like the first day, they tell you this, you're going to say this a lot. So I'm very excited whenever I get to say it. It depends. I can tell you that within the last year, we got an EB1 through an adjustment of status, the second step, through a journalist who was the head of a newsroom for a European news organization that I would say is pretty left-leaning. So, and he had zero issues, and he had some potential lifestyle issues that could be, quote unquote, offensive to a more right-leaning administration. We didn't see an issue there. But that doesn't mean that every reviewer doesn't have some kind of undisclosed intention when they're going through a petition, or that there has been some kind of document that's passed through USCIS that, save for FOIA, we might not ever be able to find out about. And I don't know if there's I don't think we're going to really get into the minutia on the consular side of it, but when it comes to the adjustment, whether when you're in the United States and you're adjusting a status, which is another bigger topic that I think we're going to stay out of for this talk. But just know that when Amanda is saying there's two steps, first step is like getting your ticket, and the second step is using that ticket to actually get your green card. Uh, that's, I think, another place where they're really going to start scrutinizing ideology. Uh, Something that we talked about before the meeting is this idea that CBP is going to be scrutinizing social media for people coming in on ESTA. That's something that's been happening for years and years for people on O1s and getting EB1s through the consulates. So we know that they are focusing on social media ideology, but they've already, through some of these exemptions and visa bans in other countries, they're already kind of doing it. And if you think about this administration, they're not using a scalpel to do it. They're saying entire countries, we're not even going to bother with people like that. So I think they're, for better or worse, this is not a regime or an administration that is probably going through things with a fine-tooth comb, as we unfortunately are seeing with how ICE is conducting operations right now. I think they are just saying no to giant groups of people without even having to get into finer issues. But let's say, for instance, you are somebody that is from a country that is not facing any issues right now. You're one of the lucky people that hasn't drawn that ire. Uh, then it comes down to what is your social media look like? What have you written about that's in the press? How potentially aggressive have you been in criticism of the current administration? In some cases, the First Amendment still exists. It still applies to people. But the issue that will come up will be, I tell clients all the time, is this like when a cop pulls you over? They have a book full of ways to pull you over that you might not even be aware of. Like your license plate is at the wrong angle. One of your stoplights, we all heard this one, is out. If they want to say no, they can find other reasons than just claiming that your politics are wrong. They can say, well, you didn't have, you had 10 categories of evidence that we agreed with, but we don't think that you had the sustained a claim or you're at the top of the field. They're using that Kazarian. So, Matthew, it's possible that that's one of the places they're using for cover. The other issue that we've talked about internally that people on this call probably unfortunately or fortunately haven't heard of is that if the consulate has an issue with a petition, they should tell you what the reason for if they're going to deny you a visa or if they're going to refuse you for the green card. They're supposed to tell you, but sometimes they don't have to go into any more reasoning than that. There's something called consular non-reviewability or the doctrine of consular non-reviewability. So we may not ever find out. So I think that is a really good question. It's a timely question. And I wish I could say, yeah, just take down stuff from your Instagram that criticizes Trump and you're going to be fine. I can't tell it because we don't know. And I don't think we're going to know how deeply ideology is affecting adjudications in not in the next 3 years.
And then I'll add to that quickly. The only other thing I think is to add to that is that, and this can be helpful to your situation or detrimental to your situation. When you're in that second step, and whether you are at the embassy and you are going to an interview, right? So that they are, hopefully going to grant you what's called an immigrant visa. And once they grant you that immigrant visa, you enter the US and then your green card is actually produced. Or if you're going to process inside of the US, either which way, you're going to interview. You are much more likely than not going to interview. It's going to be whether you interview at the embassy or whether you interview with USCIS at a local office. So in those instances, if they want to, they can ask you about maybe your social media posts, or they can ask you maybe about your work, if your actual substantive work is political in any way, or critical of any of the topics that our government has chosen to target. And it can be good because you might be able to explain it away. I don't mean away, but explain yourself, right? On the flip side, it could be detrimental if they are truly trying to take you down this rabbit hole of believing that you hold beliefs that are detrimental to, the culture of America.
Awesome. Thank you. It's a tough question. And it's tough because there's obviously so many things going on that are wrong right now when it comes to immigration, that it's hard to say, well, it actually might be fine. It's a weird moment, but that's actually, I think across the board, what we're seeing is there's a dichotomy between the actual application of these new kinds of enforcement and at least in when we're talking about O1s and PVs and the kind of stuff that we do with artists, we're seeing way more fear than actual practice. The bark is way louder, way worse than the bite. And that kind of is part of the strategy that by creating a situation where people don't even try to get visas because they think, oh, this is never going to work in this current climate, then they don't even have to do the enforcement. It just sort of does. We people do it for them, and that's a big problem, I think. There's a question here. I'm currently on an O1 and submitting an EB1 application that is received and then pending. If I'm currently on an O1 and submitting an EB1 application that's received and then pending, do I have any limitations at all when it comes to travel and work? Or is it all per usual until my O1 expires? You're on mute.
Sorry about that. Okay, I'm going to make a big assumption here. The assumption is that all you have filed is just for the eligibility. So if you have only filed that I-140 form, and that is where you're arguing your eligibility, then no, it is business as usual on your O. Like I said before, that does not affect your ability to come and go. And that's one of the bigger reasons why we, highly recommend you got to make sure that your underlying status, like your O, is valid during this time.
Great. Can people on asylum with a pending asylum application apply for an EB1?
That's a very that has a lot of elements to that answer, but generally the answer is yes. That you're not precluded from going for it. It's just you definitely need to speak to a lawyer to be able to tell you, one, assess where you are in the asylum application process, and then, and advise you on the best way to go about it if you wanted to.
Yeah,
I just
that's
wanna-
something. Go ahead.
I just want to quickly add, it's the idea there's a difference between being eligible and being admittable or admissible. And that's a huge, giant question. And I think Amanda, that's handled it exactly how I would handle
Yeah. Next question. If you have never done an O1 and are Canadian, having done many P2s, is it possible to jump straight to a green card? Totally.
I mean, it's possible.
Totally.
It's possible.
Yeah. And that actually, there's another question I have that sort of relates to that, which nobody asked, but I'm curious about. Actually, I think I know the answer. But are there situations, especially for touring artists, where you wouldn't want a green card? Where you would want to stay on an O1 for 20 years. What would be the reason why you'd want to do that?
Go for it, JR.
Oh, I can handle that, and I think I need to be reminded of the first part of the question because my memory is like a goldfish. Uh, so, well, now I've actually forgotten all the question. So,
Okay, so I'll
Is there
jump
a
in. It's fine.
situation where somebody wouldn't want to
yeah,
go for a
yeah.
green card, where
So
you'd want to stay on an O1 indefinitely?
Amanda already touched on this. Taxes, taxes, taxes. You want to talk to a tax attorney before you get involved in this process because there is potential penalty if you decide to stop being an EB1 with I think it's like 6 to 8 years if you relinquish the EB1. There is a tax penalty associated with it. The other thing, in addition to saying it depends, that I love being able to do is say, talk to a tax attorney because this is outside the scope of our practice. So I can tell you that there is a tax issue that could come up. EB1, this is a big deal. This is your life. You are coming to the United States to live. That's the other thing. You are telling the government you are going to live here permanently. That's lawful permanent resident. This isn't a commuter visa. This isn't like, yeah, I'm going to spend 6 months in France. I'm going to spend another month in Canada, and then I'm just going to come in and out like I did on my O1. That's not the case. And CBP would be very happy to, if you have a bunch of entries in and out and it looks like you're not living here, they'd be happy to take you into secondary. And secondary is when they take you to, for those who haven't had to deal with this, a little room in the airport, and they basically interrogate you about your immigration status. They'd be happy to say, hey, what's going on? What's the deal? Give us more information. Uh, so if you're not sure, EB1 is not something you should be thinking about. You have to be prepared to be here permanently, understand there's a tax consequence. And I'll kick the rest to Amanda.
Yeah, exactly. I was going to say, I know I said before, so I'm going to clarify because you know, it's actually, it is such a gray area. JR saying, coming and going and like living in France for 6 months. And then, absolutely. The Customs and Border Protection, each time you come in, they're looking at your travel record. They're wondering what you're up to, right? They might ask you what you're up to. That said, I mentioned plenty of performing artists who tour the world, right? Or visual artists who exhibit all over the world. And the point is if you are an artist or a creative who travels the world, that does not preclude you from getting the green card. But what it does mean is that the government expects that your primary residence, your primary place of residence is the United States. So as long as your home is in the United States, it's clear you're working a lot in the United States. If you're traveling a lot for work, that's okay. That's fine. And then I'll go one step further and even say, should something in your life occur where you really do need to leave the US for a prolonged amount of time, and by prolonged amount of time, I mean more than 6 months, right? So let's say that a family member gets sick and needs your care, and you really need to go. One of the more important, reasons to be working with a lawyer is you can tell that lawyer and they can explain to you there is such thing as a reentry permit. So there are ways that you can be prepared, and you can put the government on notice that despite the fact that you're going to be outside of the United States for a prolonged amount of time, it is not negating your intent to keep the U.S. as your primary residence. So it's important to know that it is flexible to some extent, but the government has a very strong expectation that you're maintaining the United States as your primary residence.
Thank you. We got a bunch of questions left, so I'm going to ask you to answer these as quickly as you can. Is an EB1 still 10 years or are they now 5 years? How long do you need to have a green card before you start the process of naturalization?
So the EB1 is generally it's a 10-year green card, right? But so here's what's important to understand. When you're granted lawful permanent residence, the green card is just the proof of it. Okay. So it's not like an O1 or a visa. Like when it expires, you don't have that status anymore. Right. So lawful permanent residence, you still have it and you still hold it. It's just you want to make sure that you're renewing your green card because that is the evidence that you have it and you hold it. Okay. You can apply for citizenship as early as 5 years of being a lawful permanent resident, but there's lots of criteria that go with naturalizing. So, you need to make sure that you satisfy all those criteria. If you travel a lot, you may need to wait more than 5 years, because there's a continuous, there's a continuous presence requirement. So it's important to look through those. Talk to an attorney about your eligibility for that if you're looking for it.
Right. Great. Thank you. This is a tax question, so you can punt it if you want to, but if you happen to feel like it's within the purview of what we talked about, go for it. Does filing taxes during an O1, during the duration of your O1 visa, do anything to support the EB1 application? I'm going to say it doesn't, but not filing your taxes when you have an O1 could screw up your EB1 application.
Matthew, you answered it.
There you go. Look. There you have it. Okay, that one's done. Have you been seeing approvals on appeal from an EB1 denials? Example, had an EB1A that got a one criterion at RFE and then got a denial, then at denial got three criteria granted but was denied Kazarian. Client was not willing to appeal. So are we seeing that any success on appeals?
We've
Thank you, Sam, for that question. But no, we go ahead, JR. We're not.
no, we
we're not appealing, right?
generally we don't like appeals because the appeal process, it's not like general civil or criminal practice where you're going to an arbiter that's going to determine based on the facts of the law. It's in our experience and the experience of other attorneys that do EB1, the appeal through CIS or through EOIR or BIA, that's going to perfect the RFE. It's very, very rare. You can go to the BIA website and look at all of the appeal decisions that come out. They're non-binding, they're not precedent, but even when an RFE is a disaster, usually when an appeal goes through, they will say, nope, it was correct to deny this. Sorry, not an RFE, a denial. So the denial was correct, and they might clean up some of the reasoning.
Mhm.
What You can do if you want. It's very expensive. You can always sue in district court under the APA, the Administrative Procedures Act is the most common way to go forth. There are a couple other very limited circumstances, but it's expensive and not everybody wants to be on the radar for suing the government because they denied their green card.
Yeah.
We have had really quickly, we had a couple of cases where we really did feel like the denials were so egregious that we should sue. And as you can imagine, as I'm sure most of you would feel the same way, our client was like, no, I do not want to sue the US government. I do not think that's going to benefit me generally. I think they're going to want to, like, I don't think that's a good idea. So we have not done that because we have not found a client willing to do so.
Yeah, and I think the other thing about this is that, unless if you're saying you're appealing in this context, the only grounds to do that is if there's a clear error that's been made. Otherwise, there's always going to be some kind of subjective cover in the way that they're denying it. Um, and it's usually cheaper to just file again and hope you get a different officer than to go through the whole appeal process. Do outstanding achievements need to be earned in the United States to qualify for a valid EB1? For example, Canada has award programs like the Juno. Are those good enough?
Those are, yeah, they can be. They can be. So no, it does not have to be within the United States.
Um, let's see. There's a question here which is very specific. It's an anonymous person, so I can't tell you who it is, but I think it's probably would, given our time frame, it'd probably be better. Just feel free to send us an email about that. I think this one is, if we haven't answered your question by the end, that probably means that it's specific enough that it's probably better off answered just directly in an email. This is not an EB1 question, but they're asking it anyway, and because we've got 2 minutes left, probably, is extending the O1 also harder these days?
Amanda's face. I'm gonna kick to me. I feel like I'm just lucky. I'm very lucky, but Amanda, what do you think?
I I want to say no. I don't think it's hard, but I take a step back and I do say, right, JR, that we have and we are ensuring that our O1s all address kind of the issues of the day that we are currently seeing. So that said, if you are a current client of ours and you are coming to us to renew, we might say to you, we might request something of you that we have not before. And if you say, well, why are you asking for this now? You've never asked for this before. We are going to say, well, it is a little hard. I mean, it is a little
Yeah.
harder. So, I kind of am saying yes and no. We're
It,
not seeing an increase in denials. Let's say that, right?
right.
There might be a slight increase in requests for evidence, right? But we are not seeing an increase in denials. I'm going to knock on wood. So,
Yeah. Yeah, I think that I would agree with that from what I'm seeing from other parts of the firm and from what we're hearing from the field is that it is harder in that the hoops are getting smaller, or they're a little higher to jump through or whatever it might be. But that is not ramifying. It's ramifying in more RFEs. It's not ramifying in more denials. Um, I think that though there was one that was submitted beforehand. Does the amount of time on your O1 on an O1 visa and working in the US give any advantage to the chances of getting an EB1? So in other words, if you've been on four O1s over the last 12 years, are you in a better position to get an EB1?
I think it helps with the Kazarian step where we're trying to prove sustained claim. If you've been somebody that is in an extraordinary ability category for a number of years, it's a little bit easier. And certainly being on a visa that covers work in the United States means it's covering a bigger part of the world where you've been working. And if you are truly extraordinary, there's an expectation that potentially you will have been working in the United States, not required. But I would argue, yeah, it helps, but also think about it in a more, sort of boring sense. You're going to have evidence that you've built over those, 12 years that could potentially help as opposed to hitting the ground with nothing. You'll have learned more, you'll have understood the process a little bit better. So I think O1 is always going to make things easier, not necessarily because there's some legal requirement to be on the O1, but just in terms of preparing for the EB.
and I'll
Good.
add to that really quickly. Sorry, really quickly. Also, devil's advocate here. you can be at the top of your field in your home country and get an EB1. So that all said, you know what I mean? Like to JR's point, yes, and I think maybe even just administratively it would be a little bit easier. But we have had a couple of clients come to us and say, I really am at the absolute top of my field in my country, and I'm coming to the US so that I can progress in my career,
Right.
and that can work.
That was the thing I was going to say is that there is that working in the US, your chances may suffer because you will be a smaller fish in a bigger pond. If you are the top of your class in a small country, it might be easier to prove your EB1 eligibility than it would be if you are just one of many people who do this thing that you do in the US. So it can cut both ways. Um, Last question. How long is it taking? At what point in the 3-year one should you be submitting for an EB1? We sort of answered that before, but just again, a year and a half out is when you should be starting to look at this. Okay.
Yep,
Yeah.
that's it. I was just about to, yeah. Go ahead,
Okay.
JR. Sorry.
I'm recommending that if you're on like your third or fourth O1, start thinking about it right after that most recent approval. But the drop dead, like the cutoff that we're recommending is a year and a half. So if you have 3 years to work on it, that's going to be the least stressful, but a minimum of a year and a
Great. Amanda, JR, thank you so much for sharing your wisdom today. Thanks to everybody who came. It's great to see this many people showing up. If there are questions you have that weren't answered here, feel free. If it's about EB1s, that is a Covey Law topic. It's not something that Thomas Dot gets into, so feel free to drop Covey Law a note. Just send it to an info, or you can go on the website and see emails to send to there. Please feel free to reach out if you have questions, and we will be announcing the topic of the next office hours, the January office hours in the next week or two. So please stay tuned, and thank you for joining us today.
half. Bye, everybody.